And most imposing of public buildings in Washington is the home of the highest judicial authority in the land.
The highest judicial authority in the land.
The Supreme Court of the United States.
Established by the Constitution as one of the three branches of the federal government, the Supreme Court enjoys equal prestige with Congress and the presidency, and exercises tremendous influence in the affairs of the nation. Though the size of the court has changed from time to time, today it consists of the Chief Justice of the United States and 8 associate justices. The highest judicial authority in the land.
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 Welcome to the inaugural educational experience that is going to be known as Article 3 Articulations. What we're going to do here is I'm going to pick a Supreme Court decision, and I'm going to explain it to you fully. I'm going to give you historical context to it. I'm going to look up if there's any law journals that have written articles about this decision. Was it a big decision? Was it a small decision? What was the outcome of the decision? Why did the justice make the decision in that way? Which I think is something that gets lost a lot in these law groups that go around on the internet. Often one or two lines is picked out of these decisions, and oftentimes they are correct about the interpretation, but sometimes they're not, and sometimes the quotes aren't real. Sometimes you look in a code or statute, and it's fake. It doesn't even exist, and that's a real problem. So this is my answer to that. So what we're gonna do here is we're actually gonna read the words from the decisions, and I'm not just gonna brush over one or two lines of it. As you'll see later, I'm gonna break it down fully. With like I said, I'm gonna include newspaper articles in this one, and I'm actually gonna explain to you why Justice Marshall made the decision he did make in this case, which I actually disagree with, but it was the decision he made, and it was the opinion of the court, and that's how it still stands today, because 18 United States v. Bevins has never been challenged or repealed. So before we can get to the case we're going to talk about today, though, which is United States v. Bevins, what I would first like to do is kind of explain what the Supreme Court is. What do they do? Why do they do what they do? How do they do what they do? How do they claim to have authority? And because I think that's an important contextual piece. Because why would we be talking about their decisions if we don't even know what they are? So first, what we're going to do is, if we're going to understand what the Supreme Court is, we need to read the Constitution. So we're going to start at Article 1, which is the legislative branch of the Constitution. Article 1, Section 1 states, all legislative power herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. So the Senate and the House of Representatives, the two bodies of government, have what's called legislative power. Legislative power is the power to make and alter laws. Put simply, they make and alter laws. So Article 1 makes the laws, and then that brings us to Article 2, which is the executive branch. Article 2, Section 1 states, the executive power shall be vested in a President of the United States of America. Okay, so that's the President. This is, Article 2 is all about the presidential powers of the United States. Which, as we go further in this educational experience, we'll come to understand that all three of these branches of government that we're going to talk about real quickly here, kind of been mashed together and muddled up and mixed around a little bit. And I think once we get there, you'll understand why the government operates the way it does today. But before we can get there, let's move on to Article 3 of the Constitution, which is the judicial branch. And Article 3, Section 1 states, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. So what is judicial power? Judicial power is the power of a court to decide and pronounce a judgment and carry it into effect between persons and parties whom bring a case before it for decision. So it's the judges. The judges have judicial power to decide and pronounce a judgment. They decide and pronounce. They say, because of the quote-unquote facts that both parties have brought, this is my judicial determination, and that is his judicial power. So, judicial power brings us to the Supreme Court, because all judicial power shall be vested in one Supreme Court. If we continue on in Article 3 of the Constitution, Article 3, Section 2, it states, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be party, to controversies between two or more states, between a state and a citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grant of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. All cases affecting ambassadors and other public ministers and councils, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Okay, so as we were reading through that, another thing came up. We had already talked about judicial power, but before you can get your judicial power, you have to have something called jurisdiction. And in here it talked about two different kinds of jurisdiction: original jurisdiction and appellate jurisdiction. So, what is original jurisdiction? Original jurisdiction refers to a court's authority to hear and decide a case for the first time before any appellate review occurs. So this is where the case starts. Somebody sues somebody else, and then you go at it in court. Unfortunately, it's not the best way to put it. But that is your what's called your court of original jurisdiction. Now, so you go through your case in your court of original jurisdiction, you don't like your judicial determination, and you feel that there is an error in the judicial determination, you can file a notice of appeal in your court of original jurisdiction, and that will notice the court of original jurisdiction that you intend to appeal to a higher court because they made a mistake. What appellate jurisdiction is, or I just want to define it for you because I've kind of explained how it works. But the definition of appellate jurisdiction is it refers to the power of a court to hear appeals from lower courts. So like I said, you don't like your judicial determination, you think the judge made a mistake, and you appeal in the appellate court, and that's how you get to your appellate jurisdiction, which 9 times out of 10, that's where the Supreme Court opinions are coming from, because people have finally gotten to the Supreme Court level and filed their writ of certiorari, and they took up the case, which they do not have to do. They pick and choose which cases they hear. So that's the difference between original and appellate jurisdiction. And before we move on to what a writ of certiorari is, I would just like to make the distinction between what judicial power and jurisdiction is, because a lot of the times they're used synonymously, interchangeably, and they're not at all the same thing. You must first have jurisdiction to have judicial power. Let's just first define judicial power again. The power of a court to decide and to pronounce a judgment and carry it into effect between persons and parties who bring a case before it for decision. So that is judicial power defined. Let's quickly define jurisdiction again. The power of a court to adjudicate cases and issue orders. So that jurisdiction is what gives that power the court to do these things, to have judicial power over the case. But if there is no jurisdiction, if the court doesn't have the power to adjudicate, which is defined as adjudicate means to make a formal judgment or decision regarding the problem or disputed matter. If they don't have the jurisdiction, they have no power to adjudicate. Okay, so let's say you finally got there. Finally went through all of the courts and you are finally at the level where you can write a writ of certiorari. The word certiorari comes from the Latin word meaning to be fully informed. A writ of certiorari orders a lower court to deliver its records in a case so that the higher court may review it. The writ of certiorari is a common law writ which may be abrogated or controlled entirely by statute or court rules. So this is a completely statutory process, and they do make you follow those rules. Appeals courts are very meticulous. That's where you get to the grown-ups, though, and they expect you to be a grown-up too, especially if you're going pro per. So, you've finally gotten to that level, and there are a few different types of writs of certiorari, and the first one is it says there are 4 types of appropriate and effective petitions for a writ of certiorari. The first type is a direct appeal in a federal criminal case. If a defendant is dissatisfied with a ruling from a district court, they may petition the Court of Appeals for review. If they are still dissatisfied with the ruling, they may request the U.S. Supreme Court review that case. So that's what I just explained to you, and that's where we're at right now. We are asking the Supreme Court to review the case. We're writing them a writ of certiorari. The second type is a petition to a state's higher court after denial by a lower court. It's kind of what I explained before. Like the federal system, most states have a similar system that allows someone charged with a crime to appeal in an appellate court. They may then submit a petition for a writ of certiorari to the state's highest court if they are dissatisfied with the outcome of the appellate court. Third type is an appeal from the highest. I should explain that actually. And so you can only get to the Supreme Court if it's a federal case, unless you're in a state case that has a federal element to it. Like there's some sort of federal question that comes up in the state case, then you can appeal it to the Supreme Court and take it to federal court. Otherwise, the highest court you can go to is your state Supreme Court. The third type is an appeal from the highest state court in a state criminal case. In this case, even if the case does not start in a federal court, the defendant can petition for a writ of certiorari for an opportunity for the U.S. Supreme Court to hear the case. This also provides an extra opportunity for the defendant that has exhausted all state judicial powers to once again review the case. Oh, okay. So I guess in criminal cases, you can also take it to the Supreme Court. The fourth type is a petition after a writ of habeas corpus is lost in a district court. If a district court denies a defendant's writ of habeas corpus, the defendant does not have an automatic right to appeal to the U.S. Circuit Courts. Rather, they must first file a request for certificate of appellability from the district courts that heard the writ. If denied, they must file a certificate of appealability from the circuit court before filing the writ with the circuit court. Okay, so that was kind of a mouthful on how you get to the Supreme Court, but that is how you do it. You got to go through a bunch of headache and trouble and be meticulous with your records and hope the judge messes up a bunch, but you can get there. And, well, unless in a criminal case, like we are going to talk about a criminal case today, actually, then it's a little bit easier to get to the Supreme Court. But in a civil case, it's pretty hard. But moving on, so you get to the Supreme Court, and so what do? What does the Supreme Court do? The Supreme Court gives authoritative opinions in the most simple terms. That's what it does. The term opinions are used on this website, which this comes from supremecourt.gov. Opinions, as used on this website, refers to several types of writing by the justices. The most well-known opinions are those released or announced in a case in which the court has heard oral argument. Each opinion sets out the court's judgment and its reasonings, and may include the majority or principal opinions, as well as any concurring or dissenting opinions. All opinions in a single case are published together and are prefaced by a syllabus prepared by the reporter of decisions that summarizes the court's decision. The justice who authors the majority or principal opinion often will summarize the opinion from the bench during the court session. Okay. So that is what the Supreme Court does. They give you authoritative opinion. And that is how SupremeCourt.gov defines it. Now, when we are reading a Supreme Court opinion, there's a couple of things that you do want to know about it because it is broken up into a couple of different sections. And in the beginning of the opinion, you are going to have what's called the syllabus. And the syllabus states right here, the syllabus is not part of the official opinion of the court. The reporter of decisions, who is a statutory officer under the direction of the court, prepares the syllabus for the convenience of the reader. It provides a summary of the background of the case, including what happened in the lower courts. Then it outlines the conclusions that the court reached in some of its reasoning. Sometimes the end of the syllabus lists the opinion in the case, noting their authors and the justices who joined them. The syllabus is in National Federation of Independent Business v. Sibelius, which upheld the Patent Protection and Affordable Care Act, is an example of how a syllabus can make a factually and legally complex case easier to understand. And I would agree. I do. The syllabus is a nice little thing to have because I think the context of the case is really important because for me anyways, it's hard to understand the opinion of the justice if I don't understand the case. I've tried just reading the opinion, I've tried just reading the determination, but it doesn't make any sense to me until I actually understand the entirety of the case. So, moving on, the majority opinion is the first opinion and the official opinion of the court in the case. This is generally known as the majority opinion, which states the outcome of the case and explains how the court reached the outcome. Sometimes the majority opinion is a unanimous opinion, which means that all of the justices agreed on the outcome and reasoning. Dissonance within the court can make unanimity elusive in major cases. However, a famous example of a unanimous opinion is Brown v. Board of Education, which struck down racial segregation in schools, which you can actually read all about. Oh, no. I do have a link. All of the cases they talk about in this little article. So after the majority opinion, you have what are called plurality opinions. Sometimes less than a majority of the court, 4 or fewer justices in modern time, agrees on the reasoning for the decision. This makes the main opinion a plurality opinion. A reader should count the justices who signed on to the main opinion to find out whether it is a majority or a plurality opinion. This may affect the impact of the case. The court suggested in Marks v. U.S. that when no single rationale explaining the result enjoys the assent of 5 justices, the holding of the court may be viewed as the position taken by those members who concurred in the judgment on the narrowed grounds. The Marks rule is difficult to apply and has been interpreted in varying ways. That as you will. And then you have concurring opinions. And a concurring opinion is if a justice agrees with the outcome of a case but not the reasoning, they may write a concurring opinion. This explains the alternative grounds on which they reached the same conclusion as the majority or plurality. Although concurrences sometimes may seem superfluous, some concurrences have been more influential than the main opinion of the case. An example is Justice Robert H. Jackson's concurrence in Youngstown Sheet and Tube Company v. Sawyer, which created a tripartite framework for analyzing the exercise of presidential power. It's probably an interesting case to read. Not one we have time to get into today, though. And then you have dissenting opinions. If a justice disagrees with the outcome of the case, they may write a dissenting opinion. This usually explains why the reasoning of the majority is flawed and why the court should have reached the opposite result. A dissent may seem like an empty gesture of protest, but some dissents have laid the foundation for future courts to overturn decisions. Justice John Marshall Harlan, who served from 1877 to 1911, became known as the Great Dissenter for authoring more than 120 of these opinions. Harlan is perhaps famous for his fiery dissent in Plessy v. Ferguson, in which he denounced the separate but equal principle behind racial segregation. And I will say, I always enjoy reading the dissenting opinions. There two particular ones are the 1873 slaughterhouse cases. All of the dissenting opinions in that case are not happy with what happened, and they stayed in there. We hope this isn't going to be used how we think it's going to be used, because that case really just gutted the 14th Amendment and made it really just not what the people who framed it intended it to be, even though that's what Miller thought when he made his decision. Anyways, moving on, there are per curiam opinions. While most opinions identify an author or occasionally more than one author, some opinions are known as per curiam opinions. These do not have individual authors, but are written by the court anonymously. One of the most memorable examples of per curiam opinions is Bush v. Gore, the case that resolved the 2000 presidential election. Don't say. That brings us to the type of opinion we're going to read today, which is a seriatim opinion. Very early in its history, the Supreme Court wrote seriatim, consecutive opinions. This is an archaic style in which each justice wrote their own opinion on a case. Regardless of whether they agreed with any of the other justices, this style tends to obscure the legal principles that arise from a case, and the court abandoned seriatim opinions in the early 19th century. An example of the style is Chisholm v. Virginia, the first major decision of the Supreme Court. And yeah, you won't see this a whole lot. The only reason you're going to read one today is because this case is from 1818. And yeah, there's 5 different opinions, 4 different people, and then there's an opinion of the court plus the syllabus at the beginning. So, and it does make it pretty confusing to read. Because, yeah, people they're just throwing stuff. The Attorney General just throws a curveball in there. I'll explain that later. It's pretty funny, actually. But those are all the different kinds of opinions. And then we get to footnotes. Footnotes in opinions. Many Supreme Court opinions come with footnotes, in which the author cites sources that support their views or further explain their reasoning. Footnotes rarely have a significant impact, but there are a few exceptions. Probably the most famous footnote in Supreme Court history is footnote 4 in U.S. v. Caroline Products Company, which set the stage for heightening judicial scrutiny in situations involving prejudice against discrete and insular minorities. It's very specific and interesting. We will go over that case one day. That's one that gets talked about a lot. I've never read the footnotes in it. But one case I do like the footnotes in is the 1873 slaughterhouse cases. Actually, there's a great one in there. I'm gonna have to pull the book that's from, I can't remember, but it's all about you owning your labor. That's really good. We'll go over that eventually later. But before we can do all of that, we need to keep on trucking, and we're going to go next to we're going to leave the Supreme Court, but we're going to go to an act of Congress, because in Article 3 Articulations, we're actually going to talk, we're going to go over two things: Supreme Court opinions and acts of Congress, because they kind of go hand in hand. Can't have one without the other. So what we're going to go over next is actually the 1789. All right, so before we move on to United States v. Bevins, I think it's important to cover one more thing, and mostly because it really confused me, especially at the beginning of this case, because in this case they throw around circuit court, district court, common law, Massachusetts district court, and then federal circuit court. They just throw around all of the different terms, and it gets really confusing to the point where I actually misinterpreted the decision the first time I read it, and I didn't actually understand it until I read it a couple times. But so shortly after the founders of this country wrote the Constitution in 1787, they realized they were going to need to do a little more work with the court system, and really start divvying up the powers and to who's actually going to do what. So in 1789, they passed an act of Congress called an act to establish the Judicial Courts of the United States, or the Federal Judiciary Act. And in this act, like I said, they really lay out what courts are going to be what. And one thing to keep in mind when we do review this is the document from 1789. The courts do not work like this anymore, with major changes. But this is how they were intended to work, and I think that's important that we understand how they were intended to work, really before we understand how they work now. So we're going to start with Section 1 and just kind of work our way down for a little bit. And we're not going to read everything because it's a really long act. So what I did was summarized everything in the document I created for this video as a study guide. So you can look through it here, and I made everything into bullet points, and I'm just going to quickly go through it because it would take us forever to go through the whole thing, and I want to get to the decision like I'm sure you do. So Section 1 is where they lay out how many justices there are going to be. There's going to be 5 associate justices and 1 chief justice. The 5 associate justices are to be a quorum, which is just a fancy word they threw in there for group. I have the definition in here somewhere. And that brings us to Section 2 and 3, which is where they set up the district courts. The divide the United States up into 13 districts, and each of them have their own district court with one judge. That's section 2 and 3 of this act. And then we move on to section 4, and section 4 establishes the circuit court. And they compose of 2 Supreme Court justices and 1 district court judge. That's who's to sit on those courts. And then they divided the circuit courts into eastern, middle, and the southern districts for the circuit courts. And we're going to get to their responsibilities right now. That's section 4 and 5. And then we're going to skip a few sections because they're not really relevant to the discussion today. Go to section 9, which is this lays out the jurisdictions of the district courts. And they have, I'm just going to quickly read them off. You can read it all in here, but I'm going to summarize this real quick. And they have exclusive jurisdiction in minor federal crimes, admiralty and maritime, seizures under impost, navigation, or trade laws, seizures on land, suits for penalties, forfeitures, penalties or forfeitures, suits by aliens, suits with the United States as plaintiff if the suit is greater than $100, suits against counsels / vice counsels, and they also lay out in all of these cases they require a jury trial except for admiralty and maritime, and that's why they love admiralty and maritime, because there is no due process. So that's sections 9 and 10, laying out the responsibilities of the district courts. And you won't get all this right now, but like I said, when you read United States v. Bevins, they're going to throw these around a lot, and you'll be able to refer to this to understand which court they're talking about and which court he was tried in first, and where they tried to move it. So that brings us to sections 11 and 12, which are the jurisdictions for the circuit court, and they have concurrent jurisdictions with state courts for civil suits at common law and equity in suits of over $500, diversity suits and diversity of citizenship or alienage, suits in district courts for crimes cognizable there. That's where they have concurrent jurisdiction, and then they have exclusive jurisdiction in most serious federal crimes. They have appellate jurisdiction in district courts, so if you get tried in the district court for one of these things, you can appeal to the circuit court, which is about the only thing that they do these days. And then they have removal jurisdiction from state courts where an alien is party or citizen of different states, or title to land under grant of another state is in question. So that's a pretty specific thing, and they have removal jurisdiction from there, and we'll just quickly define that. And removal refers to the power of defendants in some state civil suits to move a case to a federal court. Generally, if the case could have been brought in federal court, there is a federal question jurisdiction or diversity jurisdiction. A defendant may demand that the case be moved or removed to federal court under 28 U.S.C. 1441. Yeah, that's removal jurisdiction. And so that brings us to section 13, which is the jurisdictions of the Supreme Court. And the Supreme Court has exclusive jurisdiction in controversies where a state is party, original but not exclusive in suits involving ambassadors, other public ministers and councils, and they have appellate jurisdiction over circuit courts and state courts as specially provided. So you appeal. So the way it works then is you would appeal. If you didn't like what happened in the district court, you would appeal to the next higher court, which would be the circuit court. And then if you don't like your determination there, you can appeal to the next higher court, which would be the Supreme Court, which is where you would get what we talked about a little bit earlier, your writ of certiorari, and that's how you would get to the Supreme Court. And then they also gave the Supreme Court these unique powers in writs of mandamus, prohibition, and habeas corpus. So we will quickly define what those are. A writ of mandamus is a writ is an order from a court to an inferior government official, ordering the government official to properly fulfill their official duties or correct an abuse of discretion. So if a judge did something crazy in your trial, or in your case at any point, you could petition the Supreme Court for a writ of mandamus, and they would tell the judge or public servant to get in line. And then writs of prohibition. Tag writ of prohibition. A writ of prohibition is a judicial order that may be used at a higher court's discretion to prevent a lower court from interfering with the higher court's determination of a case pending an appeal. To prevent a lower court from interfering with the higher court's determination of a case pending appeal. Oh, so before before the appeal would actually get to the higher court, you would write a writ of prohibition to keep it, if you wanted to keep it in the lower court. And then the last one is writ of habeas corpus, which we have all heard of, but probably not many of us can define. So let's do that real quick. Writ of habeas corpus is Latin meaning for "you have the body." A writ of habeas corpus generally is a judicial order forcing law enforcement authorities to produce a prisoner they are holding and to justify the prisoner's continued confinement. Federal judges receive petitions for a writ of habeas corpus from state prison inmates who they say their state prosecution violated federally protected rights in some way. That's what a writ of habeas corpus actually is. And that's all we got for the Judiciary Act. When you read the case, you might want to review this particular part. It will make it make a lot more sense. But no further ado, let's move on to what we're here to talk about. I think we're finally ready to move on to our first opinion, which is United States v. Bevin, 16 U.S. 336, which happened in 1818, a long time ago. And this included a newspaper article here from just after Bevins has lost the case. So on Wednesday, came before Honorable Judge Story and Davis the trial of William Bevins, a Marine in service of the United States, on the charge of having killed Peter Landstrom, a seaman on board U.S. ship Independence, a short time since the trial continued until Thursday evening, when the jury returned a verdict of guilty of murder. Sentence has not passed on him as his counsel moved an arrest of judgment. So they filed for an injunction before he got sentenced, and on the question of jurisdiction. And that is why it got pulled to the Supreme Court. The Attorney General asked for it to go there, and it did. So that brings us to the actual case. And this is the part of the case called the syllabus. And in future cases, this is a section I will not spend a lot of time on, but this is where they explain everything in the case and a little bit of the historical context. But I want to try to add even more, and in future cases, it'll be a more major part of the decision too, because like I said before, this is actually a seriatim case, so there's 5 different opinions from 4 different people. Webster went twice, even though he first time was adequate, but before we get to the opinions, we have to go over the syllabus, which is kind of what the article just went over. But in the case, it says, admitting that the 3rd article of the Constitution of the United States, which declares that, quote, the judicial power shall extend to all cases of admiralty and maritime jurisdiction, end quote, vested in the United States exclusive jurisdiction of all cases, and that a murder committed in the waters of a state where the tide ebbs and flows, in a case of admiralty and maritime jurisdiction, Congress have not, in the 8th section of the Act of 1790, Chapter 9, quote, for the punishment of certain offenses against the United States, so, end quote, so exercise this power to confer on the courts of the United States jurisdiction over such murder. What the fuck does that mean? So, they say, admitting on the 3rd section of the Constitution, so they're saying, according to the 3rd section of the Constitution, the Supreme Court shall have exclusive jurisdiction over all cases of admiralty and maritime jurisdiction. And they go on to further state, in this act of Congress, the Act for Punishments of Certain Crimes Against the United States, Section 8, is where they brought the suit from initially. And that is where they are challenging the jurisdiction of it. They are saying, because he was finally convicted of murder in the Massachusetts District Court, Circuit and District Court, and then they finally filed for an injunction before he was sentenced on the question of jurisdiction, and the Attorney General, we'll see in a little bit, felt it appropriate because of the question of jurisdiction. He felt it appropriate to bring it to the Supreme Court. But they're saying in this section that Congress did not exercise the power to confer on the United States over such murder. So they're saying this section did not give jurisdiction to the courts of the United States, even though the Supreme Court has exclusive jurisdiction over admiralty and maritime. And we will explain that all later. So, we'll quickly go over Section 8. This is the Act for Punishment of Certain Crimes Against the United States. And basically in here, they say that if a person or persons shall commit upon the high seas or in any river, haven, basin, or bay out of the jurisdiction of any particular state murder or robbery or any other offense which is committed within the body of a county would by the laws of the United States be punishable with death. So since he lost in the United States courts, William Bevins would have been put to death had he not appealed to the Supreme Court. So that brings us to our query, which is the question of the case: whether courts of common law have concurrent jurisdiction with admiralty over murder committed in bays, etc., which are enclosed parts of the sea. So that's why are we here? That's the question that ultimately came up. And it states further in the syllabus, Congress have power to provide for punishment of offenses committed by persons serving on board a ship of war of the United States, wherever that ship may lie. But Congress have not exercised that power in the case of a ship lying in the waters of the United States. So they're saying they could have, but they didn't. In the third section, and it states in the third section of the same act we just stated that the third section did not extend to ships of war, and the Justice Marshall will go on to say that is why he made the decision, because they could have put it in here, but they didn't. So, that is why the case got brought to the United States courts, and this is what actually happened, the type of offense, and we went through it a little bit. But the defendant, he was indicted for murder in the District of Massachusetts. That's the District Court of Massachusetts. That's where he was originally indicted for the murder. And then, because remember we talked about before, they have, the District Court has exclusive original jurisdiction in admiralty and maritime. So he would have started in the District Court of Massachusetts, lost there, appealed to the Circuit Court because the Circuit Court has appellate jurisdiction over the District Court. He lost in the appellate Circuit Court, and brought it to the Supreme Court to see if it could get it brought to the common law courts of Massachusetts, so he would not get put to death. I'm assuming that was his entire reasoning behind going through all of this, because he didn't want to get put to death. So, we basically went over that in the newspaper article. It's just going over it. It was in November of 1816 on board warship Independence. They were both duly listed. The ship, and then it goes on to say where the ship was. The said ship was at the same time lying at anchor in the main channel of Boston harbors in the waters of a sufficient depth at all times of tide for ships of the largest class and burden. So that's a fancy way to say it was sitting in the Bay of Boston Harbor. There's another newspaper article saying it was tried in the circuit courts. Again, went from district to circuit. And then the civil and criminal process of the courts of Massachusetts have hitherto constantly been served and obeyed. They've constantly been served and obeyed for crimes committed in the same harbor. The The prisoner was first apprehended for the offense in the District of Massachusetts, meaning the federal government first came and got him. They didn't even give a chance to the common law courts. The jury found a verdict that the prisoner, William Bevins, was guilty of the offense. And then after the verdict, moved for a new trial. Upon the motion, 2 questions occurred. The first question being whether upon the foregoing statement of facts, the offense charged in the indictment and committed on board the said ship, as aforesaid, was within the jurisdiction of the state of Massachusetts or any court thereof. The second question being whether the offense charged in the indictment and committed on board the said ship, as aforesaid, was within the jurisdiction or cognizable of the Circuit Court of the United States for the District of Massachusetts. So, number 1, was this within the jurisdiction of the state of Massachusetts or any court thereof? And the second question, was this cognizable in the Circuit Court of the District of Massachusetts? Which one was it? That's the 2 questions. Upon the request of the District Attorney of the United States, the same questions were ordered by the said court to be certified under the seal of the Supreme Court to be finally decided, meaning they sent it to the Supreme Court to get a final judicial determination on this question. So that finishes up the syllabus. And now we move on to Mr. Webster's opinion, which is the one, Daniel Webster, the famous lawyer from in his time. He was on, I think it said 200, over like 200 arguing over 200 cases before the United States Supreme Court in his career. So he wasn't a justice, but he did this. He made arguments before the court. And he made the argument for the defendant. He was the Webster's lawyer. And we're not going to spend a whole lot of time on these. I did want to touch on them though, because I do think they're important. I want to touch on Webster. Like I said, Webster gives 2 opinions. We're only going to go through his first one. I do provide annotated PDF, like you see here, that you can go through and read everything, which I do recommend. I recommend you read the case as a whole. Especially maybe after watching this video, and you'll already have the context to understand what these guys are saying, but you'll have really the full picture because Webster does give 2 opinions. We're only going to go over one though, because I don't think it's really necessary to go over the other one. But the whole premise of Webster's argument, the first one and the second one, is that the murder was not committed on the high seas because it was committed in a port or harbor, and ports and harbors are not parts of the high sea. And that jurisdiction of the common law of Massachusetts and maritime circuit courts are concurrent, and the physical location of the offense was in a port or harbor within the jurisdiction of Massachusetts. Prima facie, the offense is not cognizable by the courts of the United States. And prima facie, that's just a fancy Latin term meaning at first sight or on the face of it. Meaning, this is how it should go, dummy. It's pretty much what he was saying. But he further goes on to state, he uses Lord Hale, and I will provide this. I think it's in the law. Yeah, treatise relative to maritime law of England. There's a PDF of the entire book right here, but this is chapter 4. And this is what the precedents, because everything in our courts are based on precedents. So before we had any United States law, we had to base everything off the precedents of English law, and that is why we adopted the English common law in the first place. That's what the settlers in the colonies adopted, because that's what they knew. It's the English common law. We had that in our courts for a really long time, until about 1938, in a case we'll talk about later. But there's chapter 4 right there. If you want to check it out, right to Bevins. But he states the Circuit Court of the the indictment is founded on the 8th section of the Act of Congress for punishments of certain crimes by which act murder is made cognizable in the courts of the United States if committed upon the high seas or in any river, haven, basin, or bay out of the jurisdiction of any particular state. To sustain the jurisdiction, in this case, then it must appear either that the place where the murder was committed was, quote, at the high seas, or that it was a river, bay, or basin not within the jurisdiction of any state. And basically just stating here that according to Lord Hale, well, he states that it was not committed at the high seas. It was committed in a port or harbor, in Boston Harbor. And he says that Lord Hale states the sea is either that which lies within the body of a county or without. The part of the sea which lies not within the body of a county is called the main sea or ocean. So he's saying right here that Lord Hale undoubtedly means the same as is expressed by high sea or mare altum. So they're saying in the eighth section of the Act for Punishment of Certain Crimes Against the United States, they say high seas, and that's equivalent to main seas or ocean that Lord Hale is stating here. And basically the second part of the question that was stated also in the syllabus, if this murder was not committed on high seas, was it committed in such haven or harbor as it not within the jurisdiction of any state? So was it outside of the jurisdiction of any particular state? And no, it was not. So if somebody would have, if they weren't on a ship of war in that harbor and they would have murdered each other, then it would have been no question. The common law courts of Massachusetts obviously would have taken cognizance over there, because there would have been no federal question. But since this was committed on a ship of war, there was a federal question. And Webster states prima facie this should be enough. He says this is obvious enough to state, but I actually disagree with him on that, because I actually agree with Justice Wheaton's opinion on that, which we'll get to in just a second. Is stating here that it is true that the judicial power of the United States extends to all cases of admiralty and maritime jurisdiction. This power is exclusive. No state can exercise any jurisdiction of that sort, which is true. And this is actually a very important point. This power is exclusive. No state can exercise any jurisdiction of that sort, meaning no state can have any kind of maritime or admiralty jurisdiction. And in 1818, this was obvious. But right around 1938, this didn't become so obvious anymore, because they changed our courts on us a lot. And through trickery and sleight of hand, they brought the admiralty jurisdiction to the states. By their own volition, they did sign it. There was nothing illegal that happened. But was it right? No. But that's where we're living right now. We didn't used to live there. Anyways, State courts of the United States cannot have concurrent admiralty maritime jurisdiction. Just reiterating what I just said. There is a jurisdiction in this case either exclusive or concurrent in common law, because the place where the murder was committed was a port or harbor, and all ports or harbors are taken by common law to be within bodies of counties, which is the whole crux of the case. And Chief Justice Marshall does agree with Webster. That's what he bases his whole argument on, is actually the word place. And I'll explain that further later. But anyways, moving on. Now we're going to talk about Mr. Wheaton's argument in the case, which is actually the argument that I agree with in this case, because Wheaton's whole argument is based on the premise that the state, he says right here, the state had not jurisdiction of the case because the offense was committed on board a national ship of war, which is extraterritorial even when in the port of a foreign country. So he's really basing his entire argument like off of international law and international principles. Because he's kind of saying that he is saying that the foreign ships of war are extraterritorial. So meaning that it means like they're their own little piece of land out there that is a little piece of jurisdiction ceded to the United States. That's what his argument is. And he says this is a fortiori when in a port of the United States, a national ship is a part of the territory of the sovereign or state to which it belongs. A state has no jurisdiction in the territory of the United States. And that's actually what I agree with. So a fortiori when in a port of the United States, a national ship of war is part of the territory of the sovereign or state to which it belongs. Meaning if a state has a ship of war, it belongs to that state. So he says a state has no jurisdiction in the territory of the United States, because he's saying that ships of war are extraterritorial, meaning they are territory of the United States and a state shouldn't have cognizance over them. That's what he is basing his argument off of, and then he makes 3 points down here basing them off of international law pretty much. In the first point, a foreign sovereign himself going into a territory of another nation in a time of peace, he is not amenable to the civil or criminal jurisdiction of the country. So if a foreign sovereign goes into a different territory, that's where you get sovereign immunity, because you're not expected to understand all of their code, statutes, laws, all the blah, blah, blah. So that's how it works internationally. And the second point, an ambassador stationed in a foreign country as the delegate of his sovereign, so one of his ambassadors, he is exempt from the local jurisdiction of the country where he resides. By fiction of law, his residence is considered as a continued residence in his own country. So meaning he follows the same laws as his own country as long as he's temporarily there. And then his third point is of any army or fleet or ship of war marching through, sailing over, or stationed in the territory of another sovereign. If a foreign sovereign or his minister or foreign ship of war stationed within the territorial limits of a particular state of the Union is in contemplation of law extraterritorial and independent of the jurisdiction of that state, a fortiori must the Army and Navy of the United States be exempt from the same jurisdiction. If they were not, they would be in a worse situation than those of a foreign power who are exempt from the state and national jurisdiction. So he's saying if it's not this way, then all of these laws are going to get crazy, because everybody's going to have to know all of the ins and outs of it. And you should treat an a fortiori, which let's go see what that is real quick, means A fortiori refers to an argument based on an even stronger previous argument. In Latin, the term literally means from the stronger. The argument implies that if the first is true, the second is even more likely to be true. So he's saying, if this is true in international law, then the stronger argument is that this should be true in United States law, because everything of the United States is considered foreign from all of the states, especially now. But that's not what happened. But that is Wheaton's argument for this, and I, like I said, I actually agree with him. A foreign ship of war would be exempt from the jurisdiction of the country. But we have seen that when they are in a foreign port, they are exempt from the jurisdiction of the country. Oh wait, and the sovereignty of the United States on board their own ships of war cannot be less perfect while they remain in any of the ports of the Confederacy than if they were in a port wholly foreign. But we have seen that when they are in the foreign port, they are exempt from the jurisdiction of that country. Exclusive jurisdiction, which the United States have in forts and dockyards ceded to them, is derived from the express assent of the states by whom the cessions are made. It could be derived in no other manner. So he's saying the only way that the United States gets exclusive jurisdiction in any fort or dockyard is if the state explicitly cedes that territory to the United States. And then he says the exclusive jurisdiction of the United States on board ships of war is not derived from the expressive assent of the individual states. The principle that every power has exclusive jurisdiction over the offense committed on board their own public ships, wherever they may be, is also demonstrated in a speech of the present Chief Justice of the United States delivered in the House of Representatives on the celebrated case of Nash alias Robbins. You know what? Actually, I need to look that case up. But he's just bolstering his argument with a previous argument, the a fortiori argument that has already been established in international law, though. The state court had not jurisdiction because the place in which the offense was committed. And actually, we'll learn later that the place, specifically the word place, is what Justice Marshall based his entire argument. Okay, so he rests his argument on, it appears by the face of the record itself that this murder was committed, in fact, quote, in a river, haven, or bay, and it has already been shown that in law it was committed out of the jurisdiction of any particular state. So that's how Wheaton feels about it. He feels he's kind of taking I guess that is an internationalist approach to it. If you were to say that the common law courts of Massachusetts didn't have any cognizance over these offenses, then that would be kind of an internationalist and not a nationalist approach to it, which I don't agree with. But, anyways, we're going to move on to the Attorney General's opinion now, which is kind of funny. It's really not important, but I kind of just want to cover it because it's funny. Okay, so the Attorney General here, his premise is, if the offense in question is not cognizable by the circuit court, it is entirely dispunishable because there is no positive law fixing the local limits of the county themselves. Okay, so what is positive law? So positive law are legal rules enacted by people in a political community. Positive law includes constitutions, statutes, and regulations. So what he's saying is there's no positive law fixing the local limits of the county themselves. It is not pretended that the place where the ship of war lay at the time this offense was committed is within the limits of the county of Middlesex by the act of the legislature of Massachusetts of March 1793. All the territory of the county of Suffolk not comprehended within the towns of Boston and Chelsea was formed into a new county by the name of Norfolk. Subsequent acts of the 20th of June 1793 and 18th of June 1803, the county of Suffolk now comprehends only the towns of Boston and Chelsea. There is no positive law fixing the local limits of the counties themselves. Locus in quo be not within the body of any county, it is confessedly within the admiralty jurisdiction. That jurisdiction is exclusively vested in the United States courts, and therefore the state court could not take cognizance of the offense. So what is the locus? Locus is just a fancy word for location, and in quo is a Latin phrase meaning in which or in what, commonly used in legal or formal context to refer to a specific situation, condition, or circumstance. So the locus in quo in this specific situation or circumstance was outside of the jurisdiction of the state because the local codes and statutes, they passed all of these acts and they were moving around the jurisdictions. They were moving around the boundaries of the counties, and he's saying that through all this stuff that there was no, I can't tell where it was. So he's saying the locus in quo be within the admiralty jurisdiction. Quote, it is out of the jurisdiction of any particular state, because all of the states have surrendered by the Constitution all of the admiralty jurisdiction they have formally possessed in the United States to the United States. Oh yeah, I did want to mention this though, because he actually, as ridiculous as his argument is, I mean, come on, bro. He does actually break down what the difference is between a merchant ship and a ship of war on the high seas, and how they are different, and how they're treated. And I actually just think it's interesting, so I just want to touch on it real quick. It says, the merchant vessel of a nation may be searched for contraband, for enemy's property, or for smuggled goods, and some have contended for deserters, whether they are on the high seas or in ports of the searching power. But public ships of war may not be searched. The first may be searched by anywhere except within the jurisdiction of a neutral state, because there all nations have a common jurisdiction, meaning on the high seas all nations have a common jurisdiction. They may be searched in the waters of the searching power, because the permission to restore to its ports does not import any exception from the local jurisdiction. The latter, public vessels, may not be searched anywhere, neither in the ports nor which they enter, nor on the high seas, not in the ports which they enter, because the permission to enter implies an exemption from the jurisdiction of the place, nor on the high seas, because the common jurisdiction which all nations have thereon does not extend to the public ships of war, which is subject to only the jurisdiction of the sovereign to which it belongs. So what they're saying there is what Wheaton was basically repeating is, if a ship of war is in a foreign jurisdiction, that power cannot search it. If it's a merchant ship, the sovereign can search that ship, but if it's a public ship of war, they can't. Every argument by which this exception is sustained as to foreign states applies to equal force as between the United States and every particular state of the Union, and is fortified by only arguments drawn from the particular nature and provision of our own municipal constitution. The sovereignty of the United States and of Massachusetts are not identical. The former have a distinct sovereignty from the separate purposes from the latter. If any particular state had in its power to intermeddle with the police and government of any army or navy, thus raised upon any pretext, there would be an end of the exclusive authority of the United States in respect. Such a conflict of jurisdiction must be terminated in anarchy and confusion. And he's just reiterating Wheaton's point is they both believe it's going to get really confusing if you let every crime cognizable on a ship of war be tried within each common law state. They're saying it's just going to be way too confusing. But that's it for all of the background stuff we want to go through. We're ready to go to the opinion of the court. Finally, all that time just to get to the opinion of the court. And before we get there, actually, I do want to make one more point. One of the reasons I even started doing this show is because I wanted to break down this case and really understand it just on my own. I wasn't going to do anything about it, really, and I went to Google Scholar and Google Scholar to get the case, and I was like, oh, you know what? This isn't actually from the record. I want to pull this case from the record so I can, download it as a PDF and highlight it and learn it a little better. So I go to look for that, and I find it right here. You can search for any case from the Library of Congress. Just type in the full report, and then you can come here and you can download the whole thing. And but when I downloaded it, I noticed that there was a lot of extra stuff in there, because you see in the Google Scholar, it's actually a pretty short case. There's not a whole lot there. But you download the actual case from the Library of Congress, and it's a 56-page document. There's about 55 pages missing from the Google Scholar from the Google Scholar site. That doesn't seem very scholarly to me. So I was like, oh man, what is going on with this? And then you read the whole case, and there's a whole bunch of different more context added to the case, and the whole merchant ship thing, for difference between merchant ship and warships. I didn't really understand that before. Not that it's really too important to the case, but when it comes to talking admiralty, maritime jurisdiction, and jurisdiction in general, it's kind of something important to understand. So anyways, I just wanted to show that. We'll move on to the opinion of the court. All right, so here we are. We finally made it to the only part that actually matters in the case. But no, that's not true. All of the context is important, especially as we move on. My favorite part of most cases is the dicta, actually, because that's where the real gravy is, if you will. Most of the time when there's a dicta on the case, that Chief Justice is not happy about the outcome, and he's so unhappy about it that he wrote his opinion down and released it to the court. So we'll talk about those later though. Let's get on to Chief Justice Marshall's opinion. And his premise is the act of Congress the defendant's claim gives the cognizance to the courts of the United States could have, but did not. Talking about the act to punish certain crimes against the United States, he's saying that act could have given cognizance to the United States, but it didn't. He's taking a textualist approach to the interpretation of the act of Congress, and the fact that the United States did not have a navy at the time. did not have a navy at the time of writing the Constitution. Marshall makes the argument that if the framers of the act, the legislation would have intended for the Admiralty and Maritime to have exclusive jurisdiction over ships of war, no matter where they lie, they would have explicitly stated so. And because they didn't, that's why he overturns the case and sends it back to the state court. The question proposed by the circuit court, whether the offense charged is in the indictment, according to the statement of facts which accompanies the question, was the offense within the jurisdiction or cognizance of the circuit court of the United States for the District of Massachusetts. He goes on to state the indictment appears to be founded on the 8th section of the Act for Punishment of Certain Crimes Against the United States. The 8th section, right here. We've gone over that before, where it gives the locations of all of the places that they have cognizance. That section gives the courts of the Union cognizance of certain crimes committed on the high seas or in any river, haven, basin, or bay out of the jurisdiction of any particular state. Whatever may be the constitutional powers of Congress, it is clear that this power has not been so exercised in this section of the Act as to confer on the court's jurisdiction over any offense committed in the river, haven, basin, or bay. Which river, haven, basin, or bay is within the jurisdiction of any particular state. Is the extent of the jurisdiction which a state possesses. What then is the extent of jurisdiction which a state possesses? We answer without hesitation. The jurisdiction of a state is coextensive with its territory, coextensive with its legislative power. The place described is unquestionably within the original territory of Massachusetts. It is then within the jurisdiction of Massachusetts unless the jurisdiction has been ceded to the United States. So he's saying that the place of the offense is unquestionably within the original territory of Massachusetts, or the common law jurisdiction of Massachusetts, unless that jurisdiction has been ceded to the United States. Okay, yeah, this is where he starts kind of throwing you a switcheroo. It is contended to have been conceded by the article of the Constitution which declares that the judicial power shall extend to all cases of admiralty and maritime jurisdiction. The argument is that the power thus granted is exclusive, and that the murder committed by the prisoner is a case of admiralty and maritime jurisdiction. Let this be admitted. It proves that the power of Congress to legislate in the case, not that Congress has exercised that power. Okay? So what he's stating here is that according to the Constitution, the courts of the United States have exclusive jurisdiction over admiralty and maritime jurisdiction. And he's stating it proves that the power of Congress to legislate in this, it proves the power of Congress to legislate in this case. That proves that Congress does have the power to pass an act of Congress over this. But not that Congress has exercised that power. It proves that they could, but not that they have. And then I provide Section 2 of the Constitution here, that he's Article 1 or Article 3, Section 2 of the Constitution that he's talking about right there. So it has been argued. Courts of common law have concurrent jurisdiction with courts of admiralty over murders committed in bay, which are enclosed parts of the sea, and that for this reason the offense is within the jurisdiction of the United States. So he's stating that since the courts have concurrent jurisdiction with the courts of admiralty over murders committed in bays, which are enclosed parts of the sea, for that reason, the offense committed is within the jurisdiction of Massachusetts. So their whole, the the argument on the United States, they're saying that the offense was committed outside of the jurisdiction of the United States, but Justice Marshall is stating that it was committed inside of the jurisdiction of the United States. To bring the offense within the jurisdiction of the courts of the Union, it must have been committed in a river out of the jurisdiction of any state. It is not the offense committed, but the bay in which it was committed, which must be out of the jurisdiction of the state. If then, it should be true that Massachusetts can take no cognizance of the offense unless the place itself is out of her jurisdiction, Congress has not given cognizance of the offense to the courts. If there be a common jurisdiction, the crime cannot be punished in the courts of the Union. So so he's stating there is concurrent jurisdiction, that the offense was committed within the jurisdiction of Massachusetts. There's concurrent jurisdiction, and since there is concurrent jurisdiction, that means it cannot be punished in the courts of the Union because the state jurisdiction would take precedence over the courts of the Union. The article which describes the judicial power of the United States is not intended for cession of territory or of general jurisdiction. It is obviously designed for other purposes. It is the 8th section of the second article. Oh, it's actually the 8th section of the first article. He makes a mistake. The 8th section of the first article, we are looking for cession of territory and of exclusive jurisdiction. Congress has power to exercise exclusive jurisdiction over the district, excuse me, and over all places purchased by the consent of the legislature of the state. And there is Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over the district as may be by cession of a particular state and the acceptance of Congress become the seat of government of the United States, and to exercise the authority over all places purchased by the consent of the legislature of the state in which the state shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And that's just, he's looking to this section for exclusive jurisdiction because it's out of Article 1, which is the legislative branch, and and that gives Congress the power to pass laws, to legislate over the territories, because Congress has ultimate power over the territories. It is observable that the power of exclusive jurisdiction is united with the cession of territories. So what is exclusive jurisdiction again? The authority only a specific court holds to hear a particular case bearing all other courts. It is observable that the power of exclusive legislation is united with the cession of territories. So you have to cede the territory in order for Congress to be able to legislate over that territory. It is not questioned that whatever may be necessary to the full and unlimited exercise of admiralty, merit, and maritime jurisdiction is in the government of the Union. The general jurisdiction over the place subject to the grant of power adheres to the territory as a portion of sovereignty not yet given away. The residuary powers of legislation are still in Massachusetts. Okay, so what is residual? Residual power. Residual power is the power held to remain at the disposal of a government authority after an enumeration or delegation of specific powers to other authorities. So he's saying basically that this Congress had the power to do it, they could have done it, but they didn't, and the territory has never been ceded to the United States. As the powers of the respective governments not stand, if two citizens of Massachusetts step into the shallow waters when the tides flow and fight a duel, are they not within the jurisdiction and punishable by the laws of Massachusetts? It may be deemed within the scope of the question certified to this court to inquire whether any part of the act has given cognizance of the murder to the Circuit Court of the United States. Okay, so since Congress hasn't passed a law to give cognizance to the United States, the residuary power is still within Massachusetts. So he goes on to state that in the third section of the Act for Punishment of Certain Crimes Against the United States, that if any person or person shall be within any fort, dockyard, magazine, or in any other place or district of the county within the sole and exclusive jurisdiction of the United States, commit the crime of willful murder, such person or persons, on being therefore convicted, shall suffer death. Which is why he's trying to get it back to the common law courts, because he wouldn't suffer death then. And then so this part is where it gets pretty confusing. So I'll try and keep you on track here. So, okay, the bay on which the murder was committed might not be out of the jurisdiction of Massachusetts. The ship of war on the deck of which it was committed is a place, it has been said, a place within the sole and exclusive jurisdiction of the United States, whose courts may consequently take cognizance of the offense. That a government which possesses the broad power of war, which may provide and maintain a navy, which may make rules for government and regulations of land and naval forces, has power to punish an offense committed by a marine on board a ship of war, wherever that ship may lie, is a position never to be questioned in this court. So he's saying it should never be questioned that a place within the sole and exclusive jurisdiction of the United States shall be punishable in the courts of the United States. He goes on to state on this section, on the 8th section of the same act, the inquiry respects not the extent of the power of Congress, but the extent to which that power has been exercised. Let me repeat that. On this section, as on the 8th, the inquiry respects not the extent of the power of Congress, but the extent to which that power has been exercised. So it's saying not that this isn't the full scope of the power of Congress. This is just the power of Congress that has been exercised in this specific instance. So this is where we get to the word place, like that I mentioned earlier. The objects with which the word place is associated are all fixed and territorial. Okay, so he's saying the word place is fixed and territorial. When the sentence proceeds with the words or in any other place or district of country under the sole and exclusive jurisdiction of the United States, the construction seems irresistible that by the words other place was intended another place of a similar character with those previously enumerated, which follows Congress might have omitted some similar places within its exclusive jurisdiction, which was not comprehended by any of the terms employed to which some other name might have been given. Therefore, the words other place or district of country were added, but the context shows that the mind of the legislature to have been fixed on the territorial objects of a similar character. This construction is strengthened by the fact that at the time of the passing of the law, the United States did not possess a single ship of war. It may therefore be reasonably supposed that a provision for the punishment of crimes in a navy might be postponed until some provision for that navy should be made. So since we didn't have a navy when the Constitution was written, it might logically be supposed that they may wait till a later date for Congress to make those laws. While taking this view on the subject, it is not entirely unworthy of remark that afterwards, when a navy was created and Congress did not proceed to make rules for its regulation and government, no jurisdiction is given to the courts of the United States of any crime committed in a ship of war, wherever it may be stationed. Upon this reason, the court is of the opinion that a murder committed on board a ship of war lying within the harbor of Boston is not cognizable in the Circuit Court of the District of Massachusetts. So, right here he states, it may therefore be reasonably supposed that a provision for punishment of crimes in the Navy might be postponed until some provision for a Navy should be made. While taking this view on the subject, it is not entirely unworthy of remark that afterwards, when a Navy was created and Congress did not proceed to make rules for regulations and government, no jurisdiction is given to the courts of the United States of any crime committed on a ship of war, wherever it may be stationed. So he's saying that other place, so when they're talking about other place in this act up here, or district of a country under the sole and exclusive jurisdiction of the United States, the construction seems irresistible by the words other place was intended another place of a similar character within the previously enumerated. And that goes back to a maxim of law, e justis, I can never pronounce it right, e justis generum, which means of like kind. That's a Latin term for of like kind. So he's saying that it's not of like kind, and if they wanted a ship of war to be in that act, they would have put a ship of war in that act. And since they didn't put a ship of war in that act, the court is of the opinion that they didn't intend for a crime committed on a ship of war in a bay or harbor of the United States. They didn't intend for that to go to the Circuit Court, the District Court of the United States. They always intended for a crime committed on a ship of war to be cognizable in the common law courts of whatever state of the bay that it was in. That's the opinion of the court. Like I said, I don't really agree with this. I think they're doing a lot of mental gymnastics here. I guess it kind of makes sense. It doesn't really make that much sense to me. But that is the opinion of the court. And they use this case in a later case in 1821, Cohen's v. Virginia, I think it is. And they really broaden and enlarge the federal jurisdiction. And I'll go over that case in a later class. All right, that's going to be it though for the inaugural educational experience that is going to be known as Article 3 Articulations. Before we depart though, I would like to just go do just a little wrap up as a little in conclusion for us to briefly review everything that we've learned throughout this whole case. And what we did learn through this decision is that if you kill someone in Boston Harbor, you will be tried in the state courts and not in the federal courts. It is not cognizable in the Circuit Court of the District. The court is of the opinion that a murder committed on board a ship of war lying within the harbor of Boston is not cognizable within the Circuit Court of the District of Massachusetts, meaning the federal courts. We went over that earlier. So the ruling has been reversed, and William Bevins is going to be retried in the state courts, and he's probably not going to be put to death. Like I said before, that's probably why he did this whole thing. And what this also does, they don't state it explicitly, but what this does is it sets up two jurisdictions. It kind of defines the lines between state and federal jurisdiction. It establishes two separate jurisdictions. One, the federal zone, which has ultimate authority over the territories of the United States. So the federal courts have ultimate authority over the territories, and that is still how it is today. It's very important. Just remember that point for in later educational experiences. But what it also did was it defined the Union State jurisdiction, which is geographical, fixed and geographical, and that the United States has no cognizance over that fixed geographical Union State jurisdiction. So that's what we learned from the case. I hope you found this as an educational experience. Please like, subscribe, and leave a comment below. I would really appreciate some constructive criticism back. What my goal is to improve this every time. And before we depart, I would like to just to kind of explain to you what I'm gonna be attempting to construct in the future is these educational law packages. And so what I'm going to be doing is putting together these educational law packages. This is almost everything that's going to be in it. Obviously, I don't have the video done yet, but what I do have done is the study guide, which you can click right here. It'll open right in the brain. You can scroll through it and click on the links. This is the study guide right here, and it's a PDF that you'll be able to download, and I put a lot of definitions on here, explanations of all of the premises of all the arguments, breakdowns of all the arguments. You can click the links right here, and it'll take you right to it if you want to do some further exploration. Or you can go right here to the brain and do that. But this won't all be here in the future. Eventually, some of this is going to be behind a paywall. The educational packages will be, but what we'll do is you'll be able to just come here and download the package yourself. So if you would like to download this one and get all of these supplemental materials that go with it in one nice, neat package, and this is how we'll do it in the future, just click download right there, right over here, and you can download and begin searching for yourself, because that's what this journey is really all about. My goal is to educate and be educated at the same time, because that is part of the process of learning, and that is ultimately why I started this experience, because I wanted to understand the law and the Supreme Court opinions specifically more thoroughly. I wanted to understand everything that I was reading. Oh, there it is. You can download it wherever you want, everything that's in there, and enjoy it yourself, annotate yourself. My annotated version is in there, and I also have, I'll just show you that in the brain. I did break everything down into
constitutional law.
And
the United States v. Bevins,
audible version.
admitting that the third article of the Constitution of the United
States, which is what I do a
States
lot. Put these in my ears because it really helps me to listen and also read these decisions, because there's so much legalese in them. It just helps ingrain it in me. And those are all in the package. All of the acts, news articles, the treatise that Webster constructed his argument on. And then these are all, click on the articles right here. These are the red ones here, pink ones, whatever, purple ones, whatever you want to call it, are law journals and other kinds of articles that reference the Bevins case. So you can just get a further understanding more from a modern day perspective too. That's what these are useful for, because these are lawyers, judges, these are the people in the law talking about the law and what it means for the common man. So that's what's going to be available there. And as always, the link for the law library is going to be available. You can click through these all yourself. What we're going to go through next is going to be Citizenship 1. That's going to be the next educational experience. And we're going to do there's 3 different Supreme Court decisions over the Butchers Union slaughterhouse cases, whatever you want to call them. But the one we're specifically going to talk about is the 1873 one, which is the one that everybody references. And the reason they reference this case is because Justice Miller, he really states it clearly, the difference between a Union State citizen and a United States citizen, because there is a huge difference between those two citizenships. Hopefully you're aware that you even had 2 citizenships, and the choice is yours on which one you want to be. But I think that's all we got for today. We're going to go ahead and wrap it up now. And I appreciate you if you made it this far. Please watch the other content on my channel. I have history content too. This Article 3 Articulations is a new thing for me, new venture for me, but all aboard. I'm working on episode 8 right now, so you can enjoy that on my Rumble channel. And I will have my website up soon, which will be truelifeproduction.com. There won't be any S on that, True Life Production. But that's going to be kind of a one-stop shop for everything for me. You'll be able to just go there and click around and get everything you need. There'll obviously be links to the law library. And you'll be able to get access to my other brain for all aboard, if you so choose. And here soon, I'm actually going to be kind of doing a little breakdown video on the law library, kind of showing you what's here, how you can search case law, how you can start digging for yourself. And we can get this thing figured out. So that's all I got for today, though. And as always, don't forget to seek truth and honor the Creator above all, and let that be the whole of the law.
That's the important thing here, is that everyone's word should be meant for a use.
And the words that I'm using today are meant to pull down idols within people's temples.
Meaning that I want to destroy
Falsities that they have idolized.
for their entire life.
And just pull those out and sweep them clean. And before that temple,
And get reinfested with a new lie. Give it true life.